the criminal defense attorney, Philip Dube, who joins us right now for some analysis on all of this. It's, it's interesting. We can put up the charges against this guy, Kelly, as Ali said, second-degree murder, aggravated assault. So second-degree murder, right, they have to say he acted recklessly, shooting this gun on his property. From the evidence as you've heard it and seen it presented, what do you make of this case?
Well, to be perfectly honest with you, I think the prosecution has got an uphill battle. I think by all accounts, there was no intent to kill. In other words, the intent at most was to warn. And if you don't have an intent to kill, then the jury cannot come back on a first-degree or a second-degree intentional murder theory. The question for the jury will be, does it rise to recklessness? And reckless is a term of art in the law. And basically what it means is that you commit a deadly act knowingly and knowing that it could cause death, and you do it in direct disregard for human life, and then a death occurs as a result of it. So even though you didn't have murder or killing on your mind, the act of firing that weapon toward human beings is reckless enough to imply an intent to kill under Arizona law, and a jury can come back with a second-degree murder based on a recklessness theory, which carries life. Now, he is asserting self-defense.
Yes.
And the jury can find that he acted in what we call perfect self-defense, or they might find that it was imperfect, meaning, okay, maybe he truly believed in the need to use deadly force, but objectively it was unreasonable, and a jury could come back maybe with a manslaughter. And I believe that carries like 7 to 15 years, and presumptively, I think 10 and a half years.
No, they didn't put him on the stand, right? Which I guess isn't very strange at all in a case like this, but was it the right move, do you think, by the defense?
Oh, yeah, there's an old adage. That is, the road to state prison is paved with many a man who took the stand, you know. Listen, anything that he had to offer or say to the jury has already been presented in evidence through his videotaped and video recorded statements, through his wife was present, through the jury visit to the crime scene itself. Whatever kernels and hopes of doubt that he has are better left based on the evidence as presented. Because let's face it, the jury will be judging him based on the evidence at the time. And if at the time that he gave all those statements and presented whatever mitigation he had, he came off sympathetic, then a jury is apt to cut him loose. But if he takes the stand and drops character and he comes off as a grouchy curmudgeon, they might imply that intent to kill or maybe even return a first-degree murder. So it's too risky. There's an old philosophy in criminal defense, and we say less is more. And if I were him, I would sit down and let his lawyer just argue for reasonable doubt and self-defense.
Which is exactly what he did. We'll see how it goes when the jury does get this case. Thanks so much for watching. Just go to joinnn.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.